Representative of the Commonwealth of Massachusetts, this court is now open. Please be seated. Good morning.
Morning.
Good morning. Good morning, everyone. Welcome to the October 7th sitting of the Massachusetts Appeals Court. My name is Marguerite Grant, and to my right is Judge Brennan, and to my left is Judge Smyth, and we will be your panel for today. Just to go over the rules of the road, each party has 15 minutes to argue. There are lights on the podium that will be green at the beginning. When you have 2 minutes left, the light will turn yellow, and that means it's time to start winding up your argument. When your time has expired, the light will turn red and start flashing, and at that point, I may interrupt you and tell you that your time is up. We do not have rebuttal in the appeals court, so the appellant should make their argument. You should all be aware that we have read the briefs very thoroughly, so my advice to you is to move into the meat of your argument as soon as possible. And with that, I will call the first case. It is number 2024 P1116, Kevin Sexton versus members of the WELLFLEET Zoning Board of Appeals. Good morning.
Please the court. My name is Albert Schultz, and I represent the appellant, Kevin Sexton. The land courts are involved with two zoning cases before the WELLFLEET Zoning Board of Appeals. The land court's interpretation that the word timber in section 6.9 of the bylaw includes all trees, including the scrub pines that were agreed were cut on the Sexton property for private parking and the permitted accessory use in the National Seashore Park District. We contend that the judge's ruling on this case is legally untenable. He cites the objectives under the National Seashore Park District as the basis for his decision that the trees could not be cut. I believe that the analysis is controlled by the Framingham Clinic, Inc. case that's cited in my brief. There, the SJC looked to ordinary principles of statutory interpretation to arrive at the decision. Specifically, the town's basis in that case was to protect and promote life. Here, the stated objective under the NSP Park District is to preserve natural and scenic areas. Objectives cannot be the basis of an opinion or a ruling by the judge. And significantly, less than 2 months after the board rendered its decision, they, in a specific case that dealt with cutting of trees, they specifically stated that cutting of trees conforms with the objectives of the district.
May I ask you about the plain language of section 6.9? Section 6.9, entitled Cutting of Timber, provides within the NSP, the National Seashore Park, there shall be no cutting of timber, and lists 3 exceptions. The first exception is by an owner for the purpose of reasonably controlling brush and trees. So isn't it fair to infer from that language or to conclude from that language that the brush and trees are included in that definition of timber?
Yes. I look at section is that clearing of brush and trees is a permitted activity, and that timber, you can, for example, if I want to build a house, or I want to improve a septic system, or I want to add on to the house that has been done for 62 years without any permits, you can clear the brush and trees, and if there happens to be timber within that area, then you can cut that timber also. You can cut the timber. But as stated in the 81 Spooner case, if there are two words in the statute, then each of them has to have meaning. There would be no reason to, so there has to be a difference.
So is your interpretation of 6.9 that one of the ways to reasonably control brush or trees is to cut them down so you can build a parking lot?
Well, building a parking lot is a permitted use in all districts, including the National Park Service. So that it has to contemplate that something is going to happen. You can't forbid all trees to be cut. That's what the board argued or found, that timber and trees mean the same thing. So the result of that would be you couldn't cut anything without a variance.
Picking up on that theme, if we're defining timber, or the board is defining timber, and we look at 6.9, it says there shall be no cutting of timber except, right? So they'll put out the except.
Right.
And the board says, well, when we promulgated these bylaws, really the only kind of trees we have down there, had and still have, are scrub pines. And anybody who's been down the Cape can probably say, yep, mostly what you see is scrub pines. So that the only meaning really that reasonably could be taken from timber would be the actual trees that exist in that particular location, no? Why not?
Well, it comes out of the federal statute. And
It seems to me the federal statute deals with what the purpose of protecting. No, am I missing that? The purpose of the bylaws to protect the native species.
Of open space.
Yeah. But if we're just strictly focused on how do we define timber, which is not defined in this particular bylaw, and again, the board says, well, based on our knowledge of the history of these bylaws and the area, that timber has to be broader, because if we limit it to trees that produce lumber or building materials, that's pretty much no trees. So this saying that there shall be no cutting of timber would mean, well, there shall be no cutting of nothing that exists in this particular place, which doesn't make a whole lot of sense. I know there's a long and involved and probably not very well articulated question. Did you get my drift?
Well, I go back to the judge's duty to look at how those terms are used in different situations, such as dictionary definitions. Right. And in the appendix, there is a definition from the 1963 Webster's Dictionary that the first definition is building material, trees that have commercial value.
And so the board says, we just follow that. So the board says, though, there were no trees in that area that could or would be used for building material,
Well,
right? That's what they say.
That's what they did say, yeah.
Okay. And why should the judge not have given deference to that, or why should we then not say, well, that's a rational and reasonable interpretation?
I don't think that's irrational. I think that's an unreasonable, because they have to define the two words differently, no matter whether there is timber or there isn't timber. But they're still oak trees That would, in the town,
Can we find that? Can we make that finding that there are oak trees in Wellfleet? Doesn't the
believe-
board know that better than we do?
I believe that it is, but I can't cite anything right now. But I don't think that that's the point of the exercise. They certainly can't use the objective. So now we get to the timber versus trees. And
It seems to me what they're saying, though, in trying to put it in words that, and ideas that click with me, is that if we interpret this bylaw as you would like us to, it could as easily have said, within the National Seashore Park, there shall be no cutting of redwood trees. But there are no redwood trees here, so what does that mean? It doesn't have any meaning in the context of where we live and what our habitat is.
But the towns, or the judge, the board and the land court said that timber and trees are the same thing and you can't cut them. So that ends the discussion. You have to go to a variance then.
I think they interpret it to mean trees are a subset of timber, as is brush.
I don't think that's what they said.
Well, back to the dictionary definition. Just out of curiosity, I looked up timber in Black's Law Dictionary, and I saw that there's something called a timber easement. I don't know anything about timber easements, but is it your position that if someone had a timber easement on someone else's land, they could only use the wood for construction and not for firewood?
Under 6.9?
Well, under how we interpret the meaning of the word timber, what timber means. You're saying it means construction wood. So if somebody had a timber easement, they wouldn't be allowed to use that wood for firewood.
If you take the town's ruling, nobody could cut, including easement holders.
We're getting a little short on time. Do you want to move to the second issue, unless.
The second is the cease and desist order said that the cutting of trees, the scrub pines for private parking, was an extension of the non-conforming use. I think that I would suggest that the applicable case is the Masselboss case. That was the case where there was a very large accessory dwelling on a lot, a non-conforming lot, and much larger than the residence, primary. The court said, no, the bylaw doesn't restrict it, as WELLFLEET doesn't restrict the size, and that goes to the appellant's assessment that there has to be some sort of size restriction, but that was rejected in Masselboss.
Can I ask, just so I'm understanding, what you're challenging on this part of it, as I understand it, and please correct me if I'm wrong, is the board's finding and the judge's affirmation of the board's finding that a change in the wooded area or from the wooded area to a parking lot is a change in use of land and therefore requires a permit. Is that essentially what you're saying that they got wrong?
No, they said it was an extension of the non-conforming use.
Okay.
But the
And
private
specifically,
parking,
that the extension would be taking the wooded lot and changing it into a parking lot, cutting down trees to make it into a parking lot. That would be the extension or the change in the use of the land.
cutting down trees isn't the use. The use of the land is the non-conforming use. And under the bylaw, the accessory use.
I ask you though, so if the use of the land right now is just as a place where trees can grow happily to the sky, and now you're changing it to pavement or dirt where cars can sit without any trees able to grow, why is that not a change in or extension in the use of the land?
It's not extending the non-conforming use. It's not a new use. It's still a non-conforming cottage colony.
Okay.
And it's a permitted use in every district, including the National Park Service. You know, and there's no, they also said that you needed a special permit. Well, there's nothing in the bylaw that says specifically that cutting trees.
That goes back, as I understand it, to 6.11, which is the no increase or addition to the non-conforming use without a special permit. So that's why it seems to me the next level down is, was this actually in addition to the non-conforming use? That's how the judges, at least I understand it, reasoned it, no?
I think that was already decided in the Masselboss case.
Okay.
I see your time is up. Thank you for your argument.
Good morning. Justin Parada for the Appellee Board. The Board's decisions here were not unreasonable, whimsical, arbitrary, and capricious, which, as the panel knows, is a very high standard, for several reasons, some of which have been discussed. The first is that their definition of timber as including the typical scrub pines that are in this district as something that can't be cut, by the way, with 3 exceptions that they didn't seek to take advantage of for some reason, is entirely consistent with the objective of the district, which is to preserve natural resources. Second, it's also entirely consistent with the dictionary definition. I'm sure you can find some, but the Merriam-Webster definition is trees or their wood. That's the definition of timber. And again, given the deference that the Board has here, it's not a 51 or 49% proposition. That's further support for the notion that the Board's decision was not unreasonable, whimsical, arbitrary, or capricious. The fact that virtually all the trees in this district are the kind that the appellant says may be cut down at will is another factor supporting the Board's decision. Again, they concede that. They conceded that here. They conceded that before the Board and before the Land Court. This question of the specific definition of the word timber and the word trees and brush being used in the same section, what I posit and what we argued in the brief is that what that is explaining is that the trees are growing and the brush is on the ground. This is referenced in our brief as well. And so timber is meant to be any kind of living thing that grows that's you would look at and colloquially call a tree, but it's also making clear that you can cut both living trees and brush if you need to do that to reasonably control those things on your property. They continue to make this argument that, well, if the Board is right and the Land Court is right, then no one can cut any trees without a variance. And that's just not true. In fact, the Land Court remanded this case to the Board for consideration of the parking issue that was discussed second by the appellant, so that the Board could consider whether or not the extension of the parking related to the college colony was a reasonable extension of nonconforming use. The issue here was that the appellant didn't give any information to either the local building inspector or the Board about exactly what he wanted to do.
Can I ask you,
Sure.
if there were no trees there at all,
Sure.
could they have just decided we're going to make our field into a parking lot? Or is that also?
No, because it's a pre-existing nonconforming, well, maybe. So the problem is we don't know how big the parking area is going to be. There's a qualitative as well as a quantitative component to that issue. In fact, the Board and the town and Land Court found some parking is allowed.
And the qualitative and quantitative parts inform what question or what issue as it relates to the bylaws?
Sure. So the first issue is, and this this didn't come up because of the posture of the case, but the Powers case drives this analysis, right? So if they have a pre-existing non-conforming use, which is a cottage colony, and they want to expand the parking, it may be that that's what's called a natural and usual use, and they don't even need a special permit.
Right.
If it's beyond what would normally be allowed with the extension, then they would need a special permit. So if they have I forget exactly how many units it is, but if they wanted to add 1,000 parking spaces to a fairly small non-conforming college colony, that would need a special permit and frankly probably wouldn't get one. But there's some level of parking that the board and everyone involved in this case agreed, sure, give us a plan. Show us a plan about exactly what you want to do, where the number of parking spaces are, and how many trees you want to cut down, and maybe you can even do it without a special permit.
And that's what the judge, seems to me, that's what the judge said.
That's what the judge said, and actually, and I did
at least
question
apply.
whether this case was even properly before you, because it was remanded, but I suppose it was remanded after judgment. But they didn't seek to take advantage of that. And that's really all I have. Just to, again, to get into this question of a variance, you know, there's multiple other ways. If there's a allowed use, residences are allowed uses in this district. Certainly when you go to get a building permit, if you have an allowed use and you need to cut some trees, the building inspector is going to say that that's part and parcel, and incidental is sort of the zoning phrase, as, you know, for an allowed use. So there's multiple ways you can cut trees. It's just, it is very controlled in this district. But that certainly doesn't render the board's decision arbitrary, whimsical, or capricious.
Does anyone in that district have to apply?
I'm sorry?
In your view, does anyone have to apply, whether you're a cottage colony, if it's a single family home next door to the college colony, and they want to cut down a bunch of trees just because they think the trees are ugly and scrubby?
Well, again, if they fall into one of those exceptions, that would be okay. And no, and the position of the town is that if it's incidental to, again, a conforming use, or residence is a conforming use.
How do they know that, I guess? How do they know that without applying? And that would be the question here.
How would the owner of the residence know? Yeah, so, well, if the residence is already there, if you're building a residence, that's an allowed use,
but
so you're going to get a
there.
building permit.
Yeah.
Yeah, so WELLFLEET does have this sort of permitting provision that you have to go to the building inspector for that, and they would request a permit to cut the trees, and you undertake the same analysis that could have happened here if they had gone to the building inspector first, rather than just doing it.
So if the cottage colony's existing parking lot, let's say one of those oak trees in WELLFLEET had an acorn that fell into the middle of that parking lot, and an oak tree started to grow in the middle of the pre-existing parking lot, could the owners cut it down without getting any permission as a reasonably controlling brush or trees?
The town would prefer they get permission. There is a permitting process for that. If they did it and the building inspector found out about it, would he file some sort of cease and desist? I can't answer that. The issue here is that he drove out there and he saw a massive clear cutting of all sorts of trees, and so that's what sort of triggered this.
Any questions? Thank you very much.
Thank you.
It was very helpful on both sides. So I'll call the next case. It is 2024 P1350, Rosenthal v. members of the Marblehead Planning Board. And we received from the appellant this morning some clearer copies, and we appreciate that.
Thank you, Your Honor. I
You're ready.
apologize again for the delay in that. Good morning. My name is Kathleen Heyer. I'm here on behalf of the appellants, Joan and Stephen Rosenthal, as trustees of their trust. So the central issue in this appeal, from our perspective, is whether the land court erred in concluding that the private defendant's property on Bartlett Court has sufficient lot frontage as defined under the Marblehead zoning bylaw for two legal residential lots, lots also being a defined term under the local bylaw. The Rosenthals contend that the land court, as did the two boards below, which the decisions were on appeal at the land court, erred as a matter of law by concluding that a driveway that's on a portion of the defendant's lot is adequate as a constructed street for the purposes of providing lot frontage. We contend that the conclusion is directly contradicted by the terms of the zoning bylaw, the defendant's deeds, and the two most recent plans of record, each of which describe the area in dispute as a lot and not a street and not a way.
That's a factual finding by the judge, right?
It's the interpretation of the bylaw. From our perspective, it's a legal interpretation, the way he defined the terms.
Okay, so you don't think it's a factual finding by the judge that that gravel section is street? Is part of the street?
Or is adequate construction?
Thank you, that's it.
Yes, we are not concluding, or we are not contending that the construction of that is adequate for the purposes of, as testified by the defendant's expert. But legally speaking, whether that can constitute a constructed street for frontage purposes, we contend is a different analysis than whether it's the physical construction of the way or driveway on the ground.
Is that a finding of fact or a conclusion of law or mixed?
We believe it's a conclusion of law because the interpretation of bylaw terms is an issue of law for the court and not a finding of fact.
So even though the judge went on a view and saw this, these pavers with the grass growing through them, and heard the testimony of the defendant's civil engineer, we could second guess that and say that's a conclusion of law, that that's adequate construction. We think it's not.
We believe that the land court erred before even getting to the question of whether it's a constructed street, that in looking at the definition of what constitute lot frontage under the local bylaw, lot frontage being defined as that part of a lot which has an uninterrupted parcel boundary line abutting on a constructed street, that the land court jumped to the latter end of that definition to look at whether he thought it constituted a constructed street, and recognizing here that the two boards below did not have the benefit of assessing whether those pavers constitute a constructed street because the pavers were added during the course of the litigation. We believe that by skipping what we contend is the first part of the analysis, one, whether there is a lot which has an uninterrupted parcel boundary line abutting the constructed street, the land court erred as a matter of law by only looking at whether there's a constructed street and not at whether the defendants have two lots that abut on a constructed street.
Are you arguing the judge was precluded from relying on extrinsic evidence?
I don't believe so. It's de novo review. It's not unusual for a fact pattern to change slightly. It's actually not even unusual for a defendant in this type of situation to come in with a new plan during the course of appeal, attempting to remedy purported errors identified at the board level below. Notably, the defendants did not do this in this case. They came in relying upon their 2021 plan, the 2010 plan, their plans, or their deeds from 2014. And although their surveyor testified that she had made an error in the 2021 plan, there is no plan of record that shows what the defendants contend is the legal lot, which constitutes 11 Bartlett, abutting a constructed street. That simply doesn't exist in this particular case.
Doesn't the auto plan that your client commissioned show that?
No, Your Honor, and there's a couple of reasons for that. One, the Otto and Dwyer plan was only of my client's property, and also critically, the area that's shown as the way and sort of fades off into the distance toward the ocean on that plan was owned by a third party at that point in time. It wasn't owned by the defendants. So it was never defined as part of the defendant's lot in that particular plan, and it was also not my client's land, so it was only there for purposes of showing dimensions. The focus of that plan was on the addition on my client's property, which was actually on the opposite side of that particular way.
Who owns the land doesn't determine whether or not an area is designated as a street. Do you agree?
I would agree with that, Your Honor.
So the prior owners before Peterson sold to Peterson, and they commissioned the Mello survey, correct, or the Mello plan?
Yes.
And that Mello plan was incorporated into the deed.
Yes.
And you're arguing that that's insufficient, the deed is insufficient to serve notice or to establish that the area of road that the defendants claim is a road, essentially you're arguing that's insufficient. There's no plan and it's not clear from the deed.
Yes, Your Honor. The Mello plan clearly shows the area or a larger area containing what they contend is now the way as being part of Lot 1. Lot 1 and Lot 2, and I believe a portion of Lot 3 on that plan were the land formerly owned by Rodney Rose and which was deeded to the Mitchells in 2009, and then they did the land swap with the Rosenthals as a result, through the Mello plan and the subsequent deeds. The 2021 plan done by the defendants mirrored the Mello plan, including the note which said Lot 1, Lot C, and Lot 3 are combined into one single lot. So that's actually consistent with the 2010 plan, and the deeds to Mr. Peterson and then the subsequent deeds all refer to it as Lot 1. And I would note that the deed specifically reserves rights over the lot shown as Bartlett Court on the 2010 plan, which of course is the remainder of the area clearly labeled as a way, for the benefit of Lot 1, and it seems counterintuitive to think you would reserve rights over a way for the benefit of a continuation of a way if it was not to be deemed a lot by virtue of that plan.
How do you respond to the defendant's argument that the 2021 plan is an approval not required plan, and therefore the fact that it doesn't depict this gravel/paver extension of Bartlett Court is not determinative?
Well, first, the pavers were not there when the 2021 plan was done, so they couldn't have showed up on the plan. They were added later. But second, there's two hallmarks of an A&R plan, and I agree with my brother that generally speaking, an A&R plan does not prove anything with respect to zoning compliance, except for the two requirements of an A&R plan are that it shows adequate frontage under the bylaw and that it has sufficient area. And an A&R plan is supposed to show those two things for zoning purposes. And in this case, it's quite clear that there is not adequate frontage on the 2021 plan.
What's your best site for the proposition that an A&R plan has to show adequate frontage, even if the point of the A&R plan is to show that the boundary line is being moved to give more side area to one of the buildings?
The statute itself says that an A&R plan has to include adequate frontage and area.
What statute is that?
That is Chapter 41, Section 81P, I believe, Your Honor. And sorry, just one moment. And I would point, Your Honor, to Pallets versus Zoning Board of Appeals of Tisbury, which is 470 Mass 795, which says that, in part, that the proponent of a plan, an A&R plan, instead of it's a subdivision, needs to show that all of the ways shown on the plan are existing ways, which is the only way that it can be recorded.
Is it your position, as a matter of law, that the showing of adequate frontage requires a recorded plan? Or are there other ways that...
For purposes of determining lot frontage, Your Honor?
Yes.
I don't think it requires a recorded plan. I mean, under the bylaw, it does say a recorded deed or a recorded plan, so I think it might be possible to look at the relevant deed. In this situation, I don't believe that helps the defendants because their deed continues to refer to the area as a lot and not a way, and says shall be combined with Lot C and Lot 3 to create one contiguous parcel, which is distinct from a street under the bylaw's definitions.
Does a property owner have a right to convert a street into a lot?
I think that depends on the circumstances, Your Honor. I mean, it would depend on who else has rights in the way. I'm not sure that's what we have here. I mean, this sort of the basis of our underlying contention is that this was always a paper street. Past the end of the paved area, it was never a formal way, and since it was never a formal way, as we've argued in our brief, it could be combined into the abutting lot as once the fee ownership came into the same ownership, which it did not until 2009, arguably.
But that's your opinion, but the judge found quite differently after taking a view, looking at aerial photographs that date back many years, and doing a thorough assessment of that area.
He did, Your Honor, and we still contend that the judge erred by skipping to the constructed street analysis without looking at what lot are we talking about that abuts on said street. And if you don't have a defined lot, which is separate from a street, and the bylaw specifically says that, the lot area specifically excludes streets. You can't have an area that is both a lot and a street. And our contention is that's where the land court erred. At the end of his analysis, after going through all of the discussion about the constructed street, the pavers, whether that provides adequate access, he said there is some area on the ground that constitutes a constructed street within either Lot C1 on the 2021 plan or what was formerly known as Lot 1 on the 2010 plan. But you can't have a constructed street and a lot by the terms of the bylaw. It simply can't be both things at once.
And what bylaw says that?
The Marblehead zoning bylaw.
What number, what portion?
So section 200-7 is the definitions of the bylaw, and they are also recreated in the agreed statement of fact, which is in the record starting at page 142.
Right, what I'm looking for is a page reference to what bylaw states that your proposition that the lot can't contain the street.
Give me 1 moment, Your Honor,
174.
and I will find that for you.
Talking about the single area of land defined by meets, bounds, or boundary lines, that definition of lot?
It's actually the definition of lot area, which is the horizontal area within the exterior lines of the lot, exclusive of any area in a street, and exclusive of any horizontal area subject to oceanic tidal action below mean high water, which is.
So that's appendix page 174.
Thank you.
But that's calculating the area of a lot. That's not saying for the proposition that a street can't pass through a lot, correct?
I mean, I would also point, Your Honor, to the definition of lot frontage, which says that part of a lot which has an uninterrupted parcel boundary line abutting on a constructed street. So if you have a lot abutting a constructed street, I would read those two terms as being completely disjunctive, particularly in the context of the rest of the zoning bylaw, which emphasizes the difference between a constructed street and a lot.
I see your light is yellow, so
It
you may
is.
want to just wind up.
Yes, thank you. So in sum, we believe it was a legal error on the part of the court to reach the decision there was adequate lot frontage without walking through the entire analysis of which lots were fronting on the constructed street. We note that it was difficult to pair the land court's findings and legal analysis against the boards just because of the work that happened on the ground during the course of the litigation. But to the extent that the judge upheld the two lower court decisions, we believe that it was an error, and at a minimum, a remand is appropriate for the proper legal analysis. Thank you.
Thank you, very helpful.
Good morning. May it please the court. My name is Sean McCormick. I represent the appellees, Stephen Peterson and Jillian Lieberman. And this case turns on just a simple physical reality, which is that Bartlett Court is a built, drivable street. It has existed for decades. And the question of whether this 2010 plan somehow got rid of the street on the ground was answered 3 times by the zoning board, by the zoning enforcement officer, and by the land court. And
So can I ask, what is the relevant point, or what are the relevant points in time from your perspective for whether the unpaved section actually was a road or a street? If I'm probably not using the term correctly.
So Marblehead adopts the subdivision control law in 1997. So when we're looking at the question of whether the way existed prior to the adoption, that's the critical moment. And that's where you see in the record all the evidence about the aerial photos and the testimony about, well, was there gravel, how constructed was it? Critically, the question of existence is a different standard than the question of adequate for today's purpose. That existence you're going to measure in 1997. Adequacy you're going to look at the time that they're applying for permits.
Okay.
So I want to just make a note that what we've been calling variously the unpaved portion or the paver portion, the grasscrete, that honeycomb-shaped pavers, that went in 2019. If you added the pavement portion and the grasscrete portion in 2019, you were just shy of 100. You need to get to 100 feet. You were at about 96 feet. During the litigation, there were about 4 feet that were added with Conservation Commission approval. So it wasn't that the entire...
4 feet of grasscrete?
That's correct, Your Honor. So I think when you look at the plan, the arguments on the Mello plan, the 2010 A&R plan.
Just so we're clear, is that Record Appendix 165?
Yes, Your Honor, 165.
I have the plan dated 2009, but it's...
So we've been calling it 2010 because I think it was recorded in 2010, but that is the plan by Mello. The argument is that that plan eliminated frontage because it combined Lot 1, which is the unpaved portion, into Lot C. But the record establishes that combination was for title purposes and not for zoning purposes. And if you look at the deeds that follow that plan, and we're looking at 248 and 250 in the record, it's clear that the purpose of drawing that plan was to allocate the ownership and not to reclassify the way. The intent in the deeds was to have the paved portion of the street, and they're referring in the deeds to that paved portion as Bartlett Court. That was going to be owned by the parties on either side as undivided. They each had an undivided 1/2 interest. Ownership of what they called Lot 1 was going to be different. It was going to be owned exclusively by Peterson's predecessor. And that's why they have two different names. And the idea that, by calling it Lot 1 instead of calling it way or parcel, that a surveyor in choosing those 3 letters would eliminate frontage and eliminate zoning compliance, not just for the one side of the street, but for the other side of the street as well. That is not supported by Massachusetts law, which is very clear that, look, A&R plans, because they lack public hearings, because they lack notice, they lack an opportunity to be heard and vetted, they can't affect those kind of substantive rights.
I thought you were talking about the 2009 plan. That wasn't an A&R plan, correct?
That was an approval not required plan.
The 2009, 2010 plan was?
That is correct. And the 2021 plan is really, it was a factual finding. There was competing testimony about whether the lack of that line that you see dividing Lot 1 from the house lot on the earlier plan, whether that should have been included and whether it was an intentional omission or a mistake.
So is your position then that the question regarding the merger of the lots is one of fact or one of law or a mixed question?
The question is, it is based on facts that the land court found. And I think once you have those facts, there's only one conclusion of law. Because merger only happens when you're curing a nonconformity. And to the extent that you have an existing way, it's on the ground, it's adequate for travel, and I think that is a factual finding that it cannot be disputed at this point. Then there's adequate frontage and there's no merger.
So back to your point about we consider the existence of the way close in time to 1997, when the zoning bylaws were put in place, and we consider the adequacy of the construction now, or when the judge was looking at it. So as I understand it, the judge considered the plan that the Rosenthals prepared, the Ott and Dwyer plan from 2000, to be the closest one in time to the 1997, and that's at RA2, page 32. And that clearly shows a gravel drive. And then the judge could rely on the photographs and his own view of the grasscrete to decide that the construction is adequate now. Sorry, I'm making such a long question here. What if there was a scenario where this existed at the time, the gravel drive existed in 1997, and then for a period of time, it was overrun by grass, and then they put in the grasscrete? Would it still be a way, even though it?
The answer is yes, Your Honor. So once you sort of get in under that, that moment when the subdivision control law is adopted, if you exist on the ground, even if you are, a country lane or a cart path, if you exist on the ground, then you move to the next question, which is, at the time that you're applying for a building permit, is it adequate for access? And here, both of those factual questions were determined by the judge in the affirmative.
So even if it was inadequate for access in the intervening years, if it's adequate for access now, that's fine?
That's right. And there's there's a case out of the land court. It's Crowley. It's cited in our brief, and it's a Judge Trombley decision, and that's the best articulation of the two different standards that existence prior to the subdivision control law. It really just requires that it be sort of evident on the ground. And the second question of adequacy for access is looked at later in time, which makes sense because our notions of what an adequate way is evolve with public safety expectations. On the issue of lot versus street under the Marblehead zoning bylaw, whether a lot can be a street, I think the answer is yes. You can have a lot which is essentially a street. There's no reason that you can't sever, put a boundary line between your home lot and your street. It is common in Massachusetts that streets are owned by the abutting landowners. There's a statute that almost does that as a matter of, or excuse me, an operation of law. So the fact that it's all owned by the same parties is not an issue. That doesn't defeat frontage. And on the Audie and Dwyer plan from 2000, I think that was really relied on by the judge as a factual matter. It was, we're looking back in time to 1997 and trying to figure out what actually existed on the ground. And the fact that there was this gravel way shown is evidence of existence as a factual matter. And I just want to be clear that it wasn't the fact that it was depicted on a plan which was sort of legally relevant. The plan was really just evidence of existence on the ground.
The same as the 1954 photo.
The same as the aerial photos, that's right. And when you combine the photos with the plans, there's a 1952 plan which shows the lots in more or less in their current configuration with the way. The judge's findings on these points are really unassailable. At the end of the day, I think what the appellants are asking the court to do is really elevate an A&R plan to be able to affect substantive rights in a way that that they simply can't do. Our best case on that is Hamilton versus Planning Board of Beverly. That's a appeals court case from 1993.
By Judge Cass.
Yes, that's right. The reasoning in that case is that, look, you can't have a world, right? You can't have a system where you can walk into the planning board with an A&R plan that would eliminate somebody else's frontage and all of a sudden cause somebody else to lose valuable zoning rights. The subdivision control law, it's sections 81T and 81W, they make it very clear that the only way to do that is with the full public hearing process. There are protections for, abutting landowners, other users of the street, and mortgagees. And if the appellant's version of the law that the 2010 A&R plan could eliminate the existing road is credited, it really subverts that whole system, and it subverts all the protections that have been recognized by this court. If there's nothing further, I just want to reiterate that the theory is that the ministerial A&R plan with no notice, no hearing, and no findings can silently wipe out zoning, and it's not the law. Frontage is determined by the bylaw definition and what exists on the ground. And on this record, there's no legal or factual basis to disturb the judgments. We respectfully request an affirmance. Thank you, Your Honors.
Okay, our third case on the list is number 2024 P1401, Kevin J. SHEA versus City of Framingham. Good morning.
Good morning, Your Honors. Should I proceed?
Yes.
So good morning. My name is Matthew Costa. I'm the attorney for the appellant, Kevin SHEA, in this appeal from the Bristol County Superior Court. May it please the Court. So our contention in this case is that the Superior Court erred when it ruled, essentially, that the Framingham City Council could upend the balance of power that is envisioned by the Framingham City Charter in a manner that was severely detrimental to my client and effectively nullified his right to a 3-year appointment and a corresponding 3-year term of employment. My client was duly appointed to, Mr. SHEA was duly appointed to the position of Director of Planning and Community Development. And I think this is a case that it's very closely tied to the terms of the Framingham City Charter. The division of, and so...
But what do we do with the fact that that 3-year term was not mentioned in the offer letter?
Well, I would cite two cases that basically state that the terms of law that pertain to a position of employment are incorporated by reference. And so when the mayor issued a letter to Mr. SHEA offering the position of Director of Planning and Community Development position with the City of Framingham, that's a term that has meaning, and its meaning comes from the Framingham City Charter that everyone in Framingham is required to work under. So there's no other conceivable interpretation of that position other than it's defined in the city charter as a 3-year term of employment as a department director.
Well, let me ask you the question that Judge Buckley asked you at argument, which is that what if your client decided halfway through the 3-year term that he got a better job somewhere else? Could he leave in the middle of the 3-year term?
He may be able to leave, and the city could potentially have recourse. That's something that happens frequently in this Commonwealth, where someone has an employment contract with their employer. And it's a complicated question because we don't have indentured servitude, so we wouldn't expect an injunction saying, no, you need to continue working for the city. But Framingham would have a reasonable expectation that he would abide by the same term and meet the requirements of his appointment, which it's undisputed that that's what he was ready, willing, and able to do, and that's what the mayor was ready to continue to respect. And under the Framingham City Charter, it's specified that only the mayor can remove department directors under a specified procedure.
So technically, they did not remove him from his position. Is that fair? They just didn't fund the position, which...
That's correct.
So theoretically, he could have stayed on there in that capacity just without remuneration.
I believe that's right. I believe that at the start of the new fiscal year, he may have been able to continue to go to work because there's no letter that revoked his appointment. But the problem is, the charter contemplates that this is a paid position. It is a director of a department of a city.
Could he have sought a raise sometime in that 3-year period?
Well, the city council voted specifically to defund his position in particular.
No, but theoretically, we're saying this is the contract. Could he have, at year 2, say, you know, this job is a lot harder than I thought it would be, or I think I'm providing more value. I think I should be paid $150,000. Could you?
Sure.
Could you give me a raise?
You could ask for that, and whether it's provided would be a matter of a decision for the city.
And then could the city then, on the other hand, say, you know, we said it was $118,000, but we really think the job is worth more like $50,000 now, so we're going to reduce your salary to $50,000. Could they have done that?
They may have. That's kind of a hypothetical, but
right.
A discussion like, there's no reason a discussion like that couldn't happen. But
so why couldn't they reduce it to 0, which is essentially what they did?
So, because effectively what that means is that the balance of power between the mayor and the city council has been totally shifted. The effective outcome of that is that the council's have the power to nullify the mayoral appointments.
Mayor had veto power on their defund, right?
That's right.
And the mayor chose not to exercise that veto power. Is that fair?
That is correct.
So doesn't that answer your balance of power issue on some level?
I don't think it does entirely. It doesn't, because the charter still has a specific procedure for removal from office. So say there was a veto and there's a budget battle, that still doesn't constitute the process for removing a city officer from their position. It wouldn't be the correct procedure. And I would say the Superior Court and the city, they've emphasized this opportunity of mandamus. But I would invite Your Honors, if you review the cases involving mandamus, they all seem to involve a situation where someone's trying title to their position. Perhaps someone's been appointed and there's an executive officer who's refusing to recognize their appointment. There's old cases when civil service came in where an executive, instead of following the civil service law, followed a different procedure, and the individuals were trying title against an executive. This case is different.
And that's the subtext in all this, it seems to me, is that this was a targeted removal. In other words, they took him out because they didn't think he was doing a good job, your client, right?
Right.
Is that relevant to the judge's consideration or then to ours in this case?
It's not, because the charter specifies that the intent, and it's explicit, the intent is to vest all power over removal in the mayor. So when the council decides, okay, well, we're going to get around that by just singling out one specific position, and not just reducing a departmental budget, but to say that individual won't get paid next fiscal year, that clearly is a violation of the intent of the charter.
Let me ask you about the City Council's appropriation powers. It's interesting to me that this was happening in June of 2021. What if your client had been, say, the Director of Parks and Recreation, and the City Council said, okay, we've just gotten through COVID, we need to change our budget, we need to put more money toward the Department of Public Health and more money toward the schools, getting kids back into schools. We're not going to have Parks and Recreation for a while. Nobody's using that anyway. So we're going to shift our budget priorities around and put more money toward the schools. Can't they do that? You're saying they're locked into the 3-year terms?
The City Council has very broad discretion, and we're not arguing that doesn't. As a legislative body, and that's why we wouldn't expect a court to issue an injunction to make an appropriation, for example, because traditionally, legislative bodies have discretion. And so, in a situation such as that, sure, there could be a discussion about priorities within the city, but the thing that's unique about this position is it's named in the charter as a position that shall exist. It shall be appointed by the mayor, it shall oversee this department, there shall be a director of planning and economic development. So
Well,
how
they did fund the department, right?
That's
At
correct.
a more minimal level, so there was someone else there.
That's
who-
correct.
Even if it was only one person or two people, if there was something that needed to be sent to the director, I'm assuming that would be sent to one of those people.
But that person wouldn't have been appointed to this position defined in the charter. They might be an interim, they might call it something. But my client was appointed by the council, so when they made the appointment, they knew they were appointing someone for a 3-year term. They knew what the terms of the charter were. They knew there would be an expectation that this person would serve for 3 years, and they knew that the charter defines it as a position that shall exist. An option for the council in that situation, if they wanted to eliminate the position, they could amend the charter. There's a legal process to do that. But they didn't do any of that. They simply kind of overruled the mayor's power. The mayor made an appropriation request, too. So that signals that this wasn't a situation where the money wasn't available. The mayor submitted a budget. And the only explanation in the record is basically that the city council didn't like this person. The charter doesn't say that it's their role to decide whether or not they like the person. The person works under the mayor and can only be removed by the mayor.
Can you explain again, and I think you did, I just still struggling with it, why this is not a situation as the city claims of a writ of mandamus?
Because if a court ordered, so if the issue was presented as to whether Mr. SHEA was the duly appointed Director of Planning and Economic Development, and the court issued the order, yes, he is, there still was no money to fund his position. So that would amount to him being like restored to a position with no funding. But when he took the job, he agreed with the mayor. He accepted her offer that it would be paid. And there's nothing in the charter that indicates that these departments...
And there was funding for the department, so I suppose they could have reallocated money toward him and then let some other folks go, theoretically, right?
I don't think so, because the budget order specified that this was an unpaid position. So I don't think the mayor has the power to like just ignore a budget order either. So there's this separation of powers. The mayor is supposed to be in charge of the appointees once they're under her direction, and the council does have authority over budgets, but they kind of took this to like the reductio ad absurdum level of saying, okay, well, we're gonna take that and completely abuse it and nullify the mayor's power to make this appointment, nullify this individual's right to get paid. He left another well-paying job for this job.
It sounds like you're arguing the mayor's rights. And if the mayor had a problem with that, the mayor could have refused to sign, the mayor could have vetoed the budget, or the mayor could have sued, like in the Springfield case.
The mayor wouldn't have sued on behalf of my client, though. I mean, there is certainly the balance of power, but my client sort of, he is the one, to use a figure of speech, he's the one left holding the bag. He's the one that lost the job. That's assuming that the mayor, would care enough about city resources to engage in litigation. My client was just left, without a position, with no severance, nothing. Just the end of an appropriation. 17 months left in his appointment. Terms of the charter that the city basically ignored or didn't follow. a letter from the mayor saying he would get paid $118,000 as an appropriate salary for this position, which he accepted. The city contends that there's no evidence of a contract, but the appointment letter dated November 3, 2019, it makes an offer. It states material terms. It asks my client to accept the offer. And so, I mean, it would
But if we're going to read into that contract the part of the charter that says 3-year terms, then don't we also have to read into it the Article 6, Section 5D that gives the city council broad authority to delete or decrease any programs or amounts?
Yes, but it says accept expenditures required by law. And I think that's an important consideration here, because it's a fair reading of the charter that this department director position that shall exist, that shall oversee this department, that the council has no power to eliminate, because only the mayor can initiate a reorganization of departments. There's been no change in the charter, that it is an expenditure required by law. The city has to pay for a department of planning and economic development. It's in the charter. Otherwise, the city council is being allowed to eliminate something that it's been legally directed to retain. So this should have been viewed as an expenditure required by law. The city council should have said to itself, we have to fund this position because the city charter says that this position exists. But instead, they voted to eliminate the funding for it, which, as a practical matter, means that it doesn't exist, because these aren't positions that individuals volunteer for. That wouldn't reasonably be expected. It would be known that the practical outcome of that is that the person leaves their position, and that's what happens. And it wasn't done voluntarily. It wasn't done with the assent of the mayor. I don't think that's a fair interpretation. We have the affidavit from the mayor that says the job would have continued if the funding existed, and that Mr. SHEA performed in a satisfactory manner. So this was an expenditure required by law. The charter has that language in it. There is so much discretion that legislatures have, but that shouldn't be deemed to nullify obligations of the city as a municipal corporation. Town meetings, city councils, they face this question all the time. There's some obligation. Sure, in theory they could vote no. In theory they could say we're not going to fund that. But what the Superior Court didn't address was that why wouldn't there still be consequences? What Framingham's arguing for is the ability to ignore its charter and not face consequences. And all my client is arguing for is that there are consequences, that if a position, I see my time is up.
Thank you.
Thank you.
Morning.
Good morning, Your Honors. May it please the Court. Catherine Fallon Manupelli on behalf of the appellee, the City of Framingham, asking this Court to affirm the decision of the Bristol County Superior Court granting summary judgment in favor of the city. And this is really the tale of two branches, the executive and the legislative branch. It's a classic checks and balances case here. The overriding issue before the court is whether the trial court was correct that Mr. SHEA's position wasn't immune from the city council's appropriating authority. And the trial court was correct. The council's action to defund Mr. SHEA's position was allowed. It was a lawful exercise of their appropriating authority, and it rendered his subsequent breach of contract action untenable, legally untenable.
So what does the language in Article 3, Section 3 mean about the 3-year terms?
The language denotes a term for the position, but it doesn't override every other provision under the law and under the charter. So the way that this is being construed is that somehow eliminates or abrogates the appropriating authority of the budget process, and it doesn't. It's the expectation that on the appointment, the individual would serve a 3-year term, but it doesn't negate the requirement for that term to be annually appropriated.
It doesn't say subject to appropriations. It simply says 3-year term. right?
The charter provision
Yes.
does,
Yeah.
yes, yes, Your Honor. And the letter...
What if Mr. SHEA had other job opportunities and he opted for this, but he said, okay, here's a guaranteed 3 years, here's where my family is at this point, and I have a 3-year job where I know what my salary is and I know at least I'm set. Is that an unreasonable expectation on his part?
It is not unreasonable, Your Honor, but it is not guaranteed. That language does not guarantee the individual appointed a 3-year term. It remains subject to the appropriation of the council annually. That is just
So
straight...
then to Justice Grant's question, why even put it there? What's the point? Does it mean, well, I'll leave the question. What's the point of having 3-year term in there? Whom does it benefit, or what is it?
It benefits, of course, for the continuity of the individual serving in the capacity, but again, it doesn't eliminate the ability for the council to remove the funding as a matter of appropriation process. So it benefits the city, but it doesn't mean that that's a contract with the city and that individual. And to the point of the question that was asked earlier, if that individual decided to leave in the middle of the term, the city wouldn't be pursuing a breach of contract claim against that individual. They would be looking to appoint someone to fulfill the balance of the term, and quite frankly, that happens a lot.
But could they? Could they say, well, you signed up for 3 years, and again, to the point, we don't have indentured servitude, but there are consequences, and if you leave before your term is up?
Absolutely not, Your Honor.
Okay.
Because this isn't a contract. It is not a contract between the city. The charter is not intended to be a contract between the city and the individuals appointed. There is no ability for this city to sue for breach of contract. And even in the cases that are referenced as supporting the position of a breach of contract, those are collective bargaining agreements. Those are statutes that create the right to an action in contract. The civil service cases that were cited by my brother, actually the law changed since then, but that the statute gives a certain termination process that's distinct from what we're talking about here. They don't support the conclusion that this was a contract and the city breached it, therefore he should be entitled to 3 years of appointment.
Is there an override mechanism in this city charter for a mayoral veto?
There is a veto, Your Honor.
There's a veto, but then does the council have any authority to override the veto?
Yes, and I would actually say in the specific instance of the budget process, the mayor could object, but the mayor can't veto the budget appropriation. And to answer the questions that were laid out, the council can't go ahead and reshape who gets what. They can only reduce or remove funding. They're limited to that. And unless there's something missing in the budget that the mayor didn't put in there or propose, the council has an opportunity under the statute to go back and add it in under a certain process. But they can't take the budget and say, I don't want to do this anymore. We don't think this is a good division. We're going to eliminate the division. That's not how it functions under the law or under the charter. But they do have the right, reduce or remove, defund or decrease under the law and under the charter. And this is just well-settled municipal finance law. It is appropriate and it is acceptable to remove funding for a position, as the council did in this case. And the reason why the city is suggesting the writ of mandamus is the available remedy here, is it's not as though anyone in that same position where they're in a municipal position that's subject to funding, that is the same exact process applies to every single one of us who's serving in a role with a designated term. Our position is subject to annual appropriation process, every single one of us. And the ability to challenge that for any type of wrongdoing would be through the mandamus, that's Chapter 249, Section 5 action. And that's why the city is saying he wasn't without a remedy here, he just didn't pursue that remedy, but the remedy that he pursued as a breach of contract is legally untenable. The mayor here has the power of the purse. She has the executive authority. She has the power of the purse to prepare the budget, to propose the budget, to persuade the council that every line item is necessary. But the council, as the legislative appropriating authority, has the power of the purse to say, no, we don't think that that's the right amount. We're going to reduce the amount. We're going to defund the amount. This is straightforward statutory process under municipal finance. And it does happen, and it did happen in this case, but it didn't create a breach of contract just because in the charter another provision said that the expectation of the term was 3 years.
Do we,
I'm sorry, go ahead.
I know the city charter is fairly new.
Yes, Your Honor.
Do we know anything from the record, the affidavit of Mr. King or somewhere like that, where that language, who shall serve 3-year terms, comes from? Is it lifted from some other city's charter? Who shall serve sounds awfully mandatory.
Yes, Your Honor. Mr. King's affidavit is in the record appendix at page 325, and he actually was one of the drafters of the charter. And I don't think we specifically addressed that question, Your Honor. But there were stated terms, and there were some terms that were coterminous with the mayor. There were some terms that have a 2-year term, a 3-year term, and that it is a very new city, and that there were provisions on the transition through the process of transitioning from the town to the city. It was a very carefully drafted, and I'm sure that they evaluated, they had a consultant assist them with evaluating what other communities did in their charters. So I'd be guessing to tell you they probably looked at what those positions called for. Some positions have a different setup than this one in the charter. This one happens to be in the charter. But I don't think it matters in this case, Your Honor, what the stated term is, because fundamentally the trial court justice said it's subject to annual appropriation. The law says that, the charter says that. So we cannot eliminate or render it immune just because of that one provision in the charter. And this is just, again, this is just the heart of the case, the crux of the case is, was his position somehow immune from the appropriating authority of the council? And it isn't. None of ours are. And the fact of the matter is the trial court judge found that most of these facts are not disputed. The one that we're going back and forth on is the existence of a contract. And from the city's perspective, there's no change in the evidence that's been presented to this court that was presented in the trial court. There really is no difference in the view of that evidence. It wasn't intended as a contract. It doesn't say it's a contract. It doesn't reference the 3-year term. It references an annual salary. It doesn't even reference the charter provisions. And it also it is quite clear that if Mr. SHEA had left in the midst of a 3-year term, another individual would be a successor fulfilling the term. And what occurred in this case, when the position was defunded, the individual who was the assistant stepped into the role. It wasn't an elimination of a department. It wasn't an elimination of a position. The council does not have that authority in the appropriation process. And to answer the question that was asked earlier, could in the midst of the service, Mr. SHEA say, I need more money? There is a process under the law and under the charter for a supplemental appropriation. It follows the same process of the council deciding whether that's in the best interest of the city and whether there's money to afford it. So again, this is just a clear balance of powers here. Because the council's appropriation authority doesn't shift anything in the mayor's appointing authority, I think that's just a misconstruction of the charter, Your Honors. The charter provision that allows the mayor the appointing authority unfettered, the removal authority unfettered, is really plain drafting that means that it doesn't have to go back to the council for approval, and it actually demonstrates that this is an at-will position. There's no hearing process. There's no time frame. There's just the requirement for the mayor to submit a letter and state, I'm removing this division head, and let the council know. There's nothing more than that. So In essence, it's just, I think there's a misconstruction of some of these provisions, and as your honors know, that there's deference given to how the city interprets it, and as the affidavit of Mr. King, who served in the town for years before it became a city, and was one of the drafters of the council, that was the evidence before the trial judge. So,
Counsel, do you believe Justice Buckley found there was a contract?
I'm sorry, Your Honor, I didn't hear
I
that.
believe Judge Buckley found there was a contract.
I
If
believe,
so, do you believe that's error?
I do not believe she even addressed that, because she specifically stated, even assuming that there was a contract, that Justice Buckley specifically stated, even assuming the existence of a contract, it didn't negate the city council's appropriating authority. It negated an action in contract because they had the power under the charter and the law to do what they did. And if there's no other
Thank you very much.
questions.
Very helpful.
Thank you, Your Honors.
Okay, we'll take one more case before we have our break. And so I will call the next case. It is 2025 P99, Michael C. Stewart versus Callahan Incorporated.
Good morning, Your Honors. May it please the Court, my name is Chris Conley. I represent Michael Stewart in this matter, the plaintiff appellant. It is against public policy to contract against intentional tortious conduct. And with that said, I want to start with the battery claim against Sean Lee.
How do you distinguish Purity Supreme?
Say again?
How do you distinguish Purity Supreme? That's the Doe versus Purity Supreme, the 1996 case where the plaintiff was raped by a fellow employee and then argued on appeal that it was against public policy for her to, I think it was a workers' comp case.
Mm-hmm.
So in other words, if the SJC said in Purity Supreme that except for certain exceptions not applicable here, intentional torts are covered by the Workers' Compensation Act, even when they're committed by co-employees.
Well, that's a correct statement of law, Your Honor. It is covered by workers' comp, and Mr. Stewart did indeed receive workers' comp. Sean Lee was not Mr. Stewart's employer. Mr. Stewart was employed by Aerotech. Aerotech was a temp agency. He was working in the care of Sean Lee.
So if the plaintiff, if Doe had been raped by a delivery guy for in the Purity Supreme back room, who was not a Purity Supreme employee, then the case would have been different?
I would say yes, under 152, General Law 152.15, which allows employees to bring third-party claims against parties culpable for damages that would otherwise be payable by workers' comp.
Sticking with your public policy argument, so the exclusivity clause of the workers' comp statute basically says you have to actively opt out of workers' comp if you want to sue your employer for damages, right?
Yes, but again, I want to be very clear. Sean Lee is not the employer here.
But isn't it the client of the employer?
Yes, which is different. So, I mean, in this...
No, but if we're just, hang on, we're talking strictly about waiving your right to pursue an intentional tort. Is that right?
Against a third party, yes. It's a third-party action, Your Honors. So Aerotech's the employer. Mr. Stewart cannot sue Aerotech for anything ever because of comp, right? Sean Lee is who he's been assigned to.
Client.
And in this situation, there's an employment contract with Aerotech. And that seeks to, well, I disagree, but what the trial judge found was that the employment contract between Aerotech and Mr. Stewart precluded Mr. Stewart from pursuing a third-party action against Sean Lee for intentional torts because comp was available to him. And I think that's wrong. And I think that's wrong for a few reasons, but I want to make sure that we're on the same page before I move on. Sean Lee is not Mr. Stewart's employer. And they are simply the people that contracted with Aerotech to get workers.
But the employment contract at RA 111 defines Sean Lee as the client.
Correct. They are the client.
And then paragraph 18 says, you waive any and all rights you have, whether arising in tort, against client, that's Sean Lee, or clients, customers, agents, officers, directors, or employees. So isn't Sean Lee the client? So you're waiving against Sean Lee.
Correct. They are the client, and that's why on the battery claim, we're saying you can't, essentially what Sean Lee has done here, the allegation, is that they've physically abused a worker, and now because of the employment contract, Mr. Stewart can't hold them accountable. And we're saying that's against
No, he can
public
be held
policy.
accountable just under the workers' comp.
No, because Sean Lee's not the employer. Aerotech paid the workers' comp.
I suppose.
Sean
I'm
Lee's the
missing your
client.
logic. I'm missing it, totally missing that. Yeah.
So Mr. Stewart works for Aerotech. Aerotech says you can go to Sean Lee, and Sean Lee's the client, right? That's the employer's client. It's a third party. And what happens is he's assaulted on the job site for poor job performance, essentially, is what we allege. And so at the trial level...
By employees of Sean Lee.
Correct, by employees of Sean Lee. And so at the summary judgment stage, I made the same argument, and what the judge said in his ruling was that because workers' comp was available, sorry, you can't go after the third party, because according to the terms of the employment agreement, that's not available to you. And it's our argument, at least now, here and at the lower level, that's against public policy because it creates a perverse incentive structure and it does away with deterrence. Because what essentially Aerotech cannot do for Sean Lee, what Sean Lee cannot do for itself, right? Aerotech cannot contract in such a way that allows Sean Lee to...
I guess I'm missing it. Are you saying the purpose of workers' compensation is a deterrent or just to make someone whole?
Workers' comp in
Or
the
any
entire
lawsuit for
workers'
that matter.
comp system is separate and apart from what we're talking about here. This is a third-party action.
So is it your position then that a purpose of someone's availability of a tort claim is to serve as a deterrent against the employees, other employees of an employer from assaulting someone, or simply you have a tort so that you can be compensated and made whole for injuries that you suffered?
Well, I think there's two parts on the tort piece, Your Honor, which is there's in a normal third-party case, there's part compensation and there is part deterrence because we do want to dissuade people from engaging in potentially harmful conduct. And I would say there's no more harmful conduct than physical violence. And in the Doherty case, and so...
Do you have any case that you can cite anywhere that says that part of tort law is deterrence?
Well, yeah, I mean, the Doherty case, which is cited in our brief, says that there's a certain irreducible minimum duty of care owed to all persons.
Sure.
That as a matter of public policy cannot be abrogated, and that's the duty to not cause harm to others. It goes on to say that you cannot contract against liability from harm for gross negligence, recklessness, or intentional conduct.
And how you read that to say that the purpose there is to deter employers from committing intentional torts on their employees?
Well, I think we should do that, but no, it's not employers, Your Honor. Again, it's a third party.
Even third, all right, okay.
So Sean Lee is a different, it's as if it were a different subcontractor on the same job site, right? It's no different.
I'm getting confused when you keep using the word third party.
Yes.
Because it's Sean Lee that you're talking about, right?
Correct.
Who is the client?
Yeah, so it's
Defined as the client in the employment contract.
Correct. So under Mass General Law 152, Section 15, you can bring a third-party action. So my employer is Aerotech.
Right.
I can't sue Aerotech, but Sean Lee's not my employer. Sean Lee doesn't write my checks. I don't work for Sean
So
Lee.
what's the significance of paragraph 18 insofar as it mentions you waive any and all rights arising in tort against client?
So I think I think the court properly disposed of the negligence claim that we advanced against Sean Lee. We can't sue Sean Lee for negligence. That's correct based on the reading of 18. But my point on the battery piece is that it is against public policy to allow such a scenario in which a third party can physically abuse employees and not be held accountable because somebody else is paying workers' comp.
Isn't battery a tort, though?
Yeah, it's an intentional tort.
So the actual person who committed the battery could be held accountable?
Correct.
Okay.
Which is Sean Lee.
And the public policy is that the employer of that should not be able to get away scot-free, if you will, just because someone else is paying the bill.
Right, so Aerotech is paying workers' comp, that's
Right.
great. And as part of this contract, that, in fact, we'll talk later, they're supposed to. But Sean Lee is a different party, and Sean Lee's employees abused Mr. Stewart on the job site. And now Sean Lee is basically benefiting from and I think it's an overreach, but I agree with the trial court, the negligence claim against Sean Lee is out, based on 18. But a battery claim, Your Honor, I think that is, as a matter of public policy, is wrong. And I think it's a
Because
perverse.
it's an intentional tort?
Correct.
Which circles back to me, I guess, that Justice Grant's original question is if the public policy, again, is to, if that's the public policy, I don't see the distinction that you're making with Doe versus Purity Supreme on a public policy basis.
I think the difference is that's a comp case, and this is not.
Is another difference, could Doe have brought a tort claim against the assailant?
Not if it was a co-employee, but if under Justice Grant's scenario where it's a delivery driver from a different company, absolutely, 100% she'd have a right to sue, without a doubt. And then there's the whole Section 15 interplay in which workers' comp is due reimbursement for monies they paid that are due. So, I mean, it all flows together within the comp statute. And so I think the key is understanding that Aerotech and Mr. Stewart, their employment agreement, that's employer-employee. Sean Lee is different. They're separate and apart. They're a third party. And so under Section 15, we can advance a third-party claim against them. Because of the employment agreement, Part 18, negligence is out, but it's our argument on the battery piece that it would be against public policy to allow Sean Lee to contract against, or to allow Aerotech to contract against liability for Sean Lee.
Before you run out of time, can you just take a moment and address why Callahan could not reasonably be considered Sean Lee's customer?
Yes, absolutely. So there's only one place in Section 18 in which Callahan could exist, and that would be in the first sentence where it's called client's customer. And so it begs the question, who is Sean Lee's customers? And in the construction context, I think it's reasonably susceptible to interpretation that it would be the owners of property for whom things are being built, right? The owners are ultimately paying Sean Lee, either directly or through the general contractor for their construction activities. And so I think the owner is the customer, but I don't have to be right. It's feasible that you could read that as Callahan is a customer. I think it would be less reasonable because I think referring to a general contractor, subcontractor relationship as a customer relationship is awkward at best. But the point is it's reasonably susceptible to multiple interpretations, and therefore it's ambiguous and must be construed in a light favorably to Mr. Stewart, which would mean not including Callahan. I think the other sentences, excuse me, Your Honors, the second sentence starts by talking about workers' comp. That's the topic and the subject of the sentence. It says, look, for workers' comp on-the-job injuries, we have workers' comp for on-the-job injuries, and you agree to look solely for Aerotech for any such claims. That's exactly what Mr. Stewart did. He went to his employer and received comp benefits. Sentence 3, which is the Horner-Molina language, refers only to the client, which, as you've pointed out, is Sean Lee. And so, again, that's another reason why the negligence claim against Sean Lee is out. So the only place that Callahan could exist is in that first sentence. And I think you have to reach, respectfully, I think you have to reach the term client's customer and ask, in these circumstances, in the construction circumstance, does that term unambiguously include Callahan as a general contractor? And I think it simply does not.
Thank you very much, counsel.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Jim Dyer. I represent the appellees, Sean Lee and Callahan. Judge Binney's memo of decision in the lower court was thoughtful and well-reasoned, and for that reason, I'm hesitant to talk too much today. I don't want to stick my foot in my mouth, which could happen. But I do want to make two important points during my allotted time. The first point is, and I think it's a very important point, is the plaintiff's employment agreement with his employer Aerotech means exactly what it says that it means. As a condition of his employment, he agreed his only recourse for any work injury was to make a workers' compensation claim. That's very apparent in paragraph 18. You can't sue Sean Lee, the subcontractor, and the client of Aerotech, and you can't sue Callahan, because Callahan has a contractual relationship with Sean Lee, a customer, if you will.
What do you say to Attorney Conley's argument that it's a rather strained reading of client in that context?
Sure.
I mean customer, not client. Customer's pretty clear. How about?
Thank you, Your Honor.
Clients.
I would say that the plaintiff is in search of ambiguity in this case, because that's the only way he's going to prevail. And the way the plaintiff is doing it, he's looking at each sentence in isolation. That's not how you interpret anything. If you're reading a book, if you're reading a newspaper, if you're reading anything, you need to see the sentence that comes before the sentence you're focusing on and the sentence that comes after. This whole paragraph 18 needs to be read as a harmonious whole and not dissecting it and pulling one sentence and looking at that sentence and saying, well, I think this one sentence standing alone is ambiguous. You have to look at the entire paragraph. The court, this mode of looking at construction is not the way Massachusetts law advises us that we have to construe documents. You have to look at it in its totality. And that's the Rubin versus Murray case, which was decided by this court in 2011.
So the paragraph 18 includes agents, officers, directors. It doesn't include subcontractors.
It doesn't include subcontractors, and Sean Lee was a subcontractor on this job, but it was a client of Aerotech under this contract. So Sean Lee gets the benefit of paragraph 18.
But Callahan's relationship to Sean Lee was what?
Well, it talks about relationships that Sean Lee has with others.
What other was Callahan?
Callahan is a customer of Sean Lee. Sean Lee is providing services to Callahan pursuant to a subcontract. That's the relationship. Sean Lee doesn't have a contract with the owner or the company that's providing steel on the job or anything else. That's the only possible relationship that Sean Lee has to anyone on this job is with Callahan, the general contractor, through this subcontract. And so that, I don't think that an analysis of what customer means is necessarily needed here, but I do believe that customer encompasses Callahan in this analysis. I also wanted to point out that the court enforced a nearly identical limitation of liability clause in an employment agreement in the Horner versus Boston Edison Company case, which we talked about in the appellee's brief. And so just looking at this whole idea of public policy and what's public policy and what's an offense against public policy and so forth, I would say that there is no offense to public policy in barring the plaintiff's battery claim against Sean Lee, because the Massachusetts Workers' Compensation Act is itself a statement of public policy. And that policy statement is that intentional tort claims occurring in the workplace are covered by the Workers' Compensation Act. And you don't have to take my word for it. You can read the Doe versus Purity Supreme case, which we've already talked about earlier today. And that case says intentional torts are covered by the Workers' Comp Act even when they are committed by co-employees. And the plaintiff acknowledged this reality when he made a workers' comp claim based on this battery that he suffered on the work site. He received medical bill payments, he received lost wages, and he received a lump sum settlement of $25,000. I think the real public policy consideration here is whether or not parties have the right to enter into contracts that are going to be enforced by the court, regardless of what the outcome may be. One party's dissatisfied, hey, I didn't think that was going to happen, but this is the way it turned out. Massachusetts favors the enforcement of contracts. There's no public policy reason that says this contract should not be upheld. The decision of the trial court was correct, and I ask this court to affirm that decision. Thank you.
Thank you both very much. We will be in recess for about 15 minutes.
pencil out, get something.
Good morning still. We will proceed with the fifth case on the list, 2024 P1443, Department of Revenue on behalf of NATALIE SHKOLNIKOV versus Daniel Jeffrey Cohen. Mr. Barrick, you may proceed.
Thank you. Good morning. May it please the court. Matthew Barak for the appellant, the mother. First, the lower court abused its discretion by failing to consider and properly weigh the best interest of the child, which is directly connected with the well-being of a custodial parent. Our courts, from Giannis and his progeny, have consistently held that because the interest of a child is so interwoven with the well-being of the custodial parent, it justifies removal of the child. And under the Giannis standard, the interests of a parent seeking removal are provided greater weight than a non-custodial parent.
Counsel, under Giannis, Giannis deals with somebody else's sole custody, correct?
Correct.
But here, the judge seemed to operate under that framework, but in fact, the mother had primary custody, but not sole. Is that fair to say?
Well, I think in the law, we have two forms of custody, obviously, the legal and physical. It is clear that mother was the primary functioning parent, and so therefore she was the sole physical guardian of the child here, and therefore it falls under the Giannis framework rather than the Mason v. Coleman analysis. So I think mother here had the child approximately 78% of the time. Father had a parenting plan that was essentially every other weekend and only a dinner visit for like an hour or two during the week. So I think it's an undisputed fact here that mom had sole physical custody. We have gone away to maybe some edification in the probate court. We've tried to go away from terms like custody and terms like visitation. So we oftentimes, when we reach agreements or when a judge does something, is it goes by what the actual time is. And in fact, in the Miller case, that's exactly what the SJC did, was they examined, because there was disputes as to what the orders in that case were and what the functional time actually was between the parties to determine that mom, in that matter, similar to this matter, had primary physical custody of the child.
So, in other words, whether there's sole physical custody or joint physical custody isn't necessarily a binary thing.
Correct. It goes by what the parties are truly doing is how it should be analyzed when we come to removal. And my grounds for that is the Miller case, because that was an issue in Miller.
So the judge concluded that it was definitely a real advantage to mother, it would be, to move to Alaska with the child.
Right.
But the judge then concluded that it would not be in the child's best interests to move to Alaska because she would lose her weekly contact with the father. What do you say to that finding of fact?
I say that is true, that there's an alteration to the parenting time between the father and the child. But I say that our case law has consistently held that that's not dispositive of the issue, that the Rosenthal case, the Rosenweiler case, Giannis specifically states it too, that because the alteration alone is one factor of 5 or 6 factors that should be analyzed under what's best for the child. And
So just, do you dispute that the judge actually addressed the factors? Even if not to your client's liking, but...
I dispute that she did the clear fact-finding that is supposed to be done in these very difficult cases. That what she did here, when you read that judgment, and you read it in light of Giannis and Miller and its progeny, that she did not properly weigh and address the fact that this mother was under economic peril, under emotional turmoil, that those factors, the fact that if mom was allowed to remove, the benefits to this child outweigh the disruption in the relationship between the father and the child.
On the weighing of the evidence, though, we'd have to find that the judge abused her discretion, right?
Correct.
Okay.
And I believe the judge did abuse her discretion, because what she did was she put her thumb on the scale of justice here and said, because there will be a disruption in the relationship between this child and this father, that outweighed any other factor. And that is not, it's the reverse that should occur. There should be greater weight to the first factor, which is who is the primary custodial parent and what benefits does that custodial parent have in removing, and how those benefits flow to the child. Because what we have now here is we have a mother who is separated from her husband, who can't afford 2 households, with a 10-year-old child that wants to be with her baby sister and an intact family in Alaska. And we would never have any case in the Commonwealth that would allow for removal if the only factor that was weighed is the fact that there'd be a disruption or curtailment to the parenting plan between the father, in this case, and the child.
Where in the judge's findings does it say that that's the only factor she weighed?
When we read it, she put in when we go to her rationale, there are at least five factors that she goes, in paragraphs, that she goes through, that when you read it as a whole, it is significantly clear that her determination to deny removal was based on the disruption. And when we read Rosenthal, when we read Rosenwasser, they all say that we cannot have a disparate emphasis upon the effects of the move related to the parenting plan for the non-custodial parent. And what she did was precisely what Rosenwasser says not to do, which is that you have to weigh collectively the interests of the parties. You have to examine the fact that mom is the custodial parent and all the benefits it would incur to her and the child, and that those interests should be given greater weight. And in fact, what she should have done is properly analyzed the fact that mother was offering a parenting plan here that was extensive and better than the parenting plan that he had.
Well,
in terms of the amount of
judge
time.
found the parenting schedule proposed by mother, which gives fathers 6 weeks during the summer and 1 weekend per month, is totally impractical. So then it goes into the fact that it takes 24 hours by plane to travel from Worcester to Fairbanks, and the father, if he was trying to get this 1 weekend a month, he'd spend more time on the plane than he would with the child. How is that not the analysis you're saying the judge should have performed?
Well, first of all, if we review the case law as instructive here, in the Miller case and the Wakefield case, they both had those same issues. Miller was in Germany, Wakefield was in St. Croix.
Well,
The child, to me, wasn't going to the moon.
Maybe there's more flights from Boston to Germany.
I don't know, but we do have flights that go from Alaska to from Massachusetts and vice versa every day. And if that were the standard, if that was the standard as how many flights, instead of the reasonable standard that the courts have held, we would not allow removal at all. Critically,
What do we do with the fact that the judge saw the mother's testimony, including when she was asked about how the child would get from Fairbanks to Worcester? And the judge made a decision based on that testimony that the mother's parenting plan was totally impractical.
I think it's an erroneous finding. I think that mom was asking for and suggesting 97 nights versus 82 nights that he has now. 1. 2, she was suggesting that he could have consistent contact with the child vis-a-vis FaceTime, videos, and the like. Those are all things that people have. The child was found had a phone.
But the problem was she found that the mother wouldn't support that. She didn't credit the mother's explanation. She explicitly didn't credit it, nor did the GAL credit the mother's promise or indications that she would change her behavior. So those seem like empty parts of the plan to the judge. Is that an error?
I disagree with those findings because the mother was found to be an excellent mother. The child was thriving and doing well by all accounts. Certainly there was a fraught relationship between the mother and the father, but these were parties that had not lived together with the child ever before.
But again,
And-
understanding you may disagree, we may disagree. I'm not saying we do, but we may say, if that were me, I might have decided differently. That's not the standard here.
No, but the standard is also not to put undue weight upon the fact that there would be an interruption in the relationship between the child and the father by mom going to Alaska. What I'm saying is this judge abused her discretion by not properly weighing all of the factors for best interest and by not properly assessing within the judgment the benefits to mother. I mean, she said she found benefits, but she doesn't go into any analysis in this judgment as to how those benefits flow to this child. These cases are difficult and they are
Some
hard to
benefits
resolve.
of removal from mother discussed above would flow to the child.
But she didn't go into how that would benefit the child vis-a-vis the interruption.
Mother would live with the stepfather and enjoy the emotional and financial support which comes with living under the same roof as her spouse. Better support for mother would benefit the child.
And-
Additionally, the child would benefit from the reduced financial burden on mother and the stepfather if they're no longer required to maintain two households. What more was the judge supposed to say?
Well, you said it yourself. All those factors support the conclusion we're seeking. All those factors, that's why it's an inconsistent judgment. All those factors, the fact that she would be with her spouse, her new spouse, the fact that she wouldn't be under financial turmoil, the fact that the child would reap those benefits, that supports the fact that this child should have been allowed to be removed. What she did was, she took those facts that clearly and unequivocally support removal and ignored them in the end by focusing entirely on the issue of a disruption in the parenting plan. And our case law is very clear that the parenting plan being altered or changed alone cannot serve as the basis of denying removal. And in fact, what is different than all these other cases, and there was not one case cited in the appellee's brief, where a parent, where this court, the lower court found a real advantage here, like they did, and did not find it was in the best interest for this parent to remove. The case that they cited in their brief is a case that did not find a real advantage. Here, the judge did. So once you find that real advantage, and once you start weighing best interest to deny.
But didn't the judge actually, on the other side of the scale, weigh what she called the effective elimination of the father's relationship with the child as to whether that would be in the child's best interest? Isn't that, and that, again, the judge came out with a different conclusion as to how to weigh those and what the ultimate best interest would be based on those two things, but it's not as if the judge ignored that part of it, no?
She didn't ignore it, but she used it as the sole basis to deny removal. And when we look at the findings that Justice Grant just read in, where is the analysis of whether the quality of the child's life will be improved, including any improvement that may flow from any improvement to the quality of the custodial parent's life? That's the first factor. Where is that in this judgment? She says it, but where is that weighed in this judgment over the interest of the adverse effect and what it says and what the law has consistently said, and citing the Rosenthal case, any possible adverse effect of the elimination or curtailment of the child's association with the non-custodial parent? That's the second factor. It's one factor of many, but that factor needs to be weighed for the child, for the custodial parent, and the non-custodial parent, and it needs to be seen through the lens of who this child is with the vast majority of the time. How does it help this child to be in a home when with her baby sister away from her stepfather, with her mother being angry and unfulfilled and unhappy because he's in Alaska in the military? How is that best for this child? And that's what this judgment does not get to. And that's why it's an abuse of discretion. And when you read the case law very carefully, the case law is pretty clear that the parenting time of the non-custodial parents cannot be the controlling factor. And that's what this lower court did, and that's why it's wrong, because it didn't address the mother's interests, the child's interests, and weigh them in an appropriate manner under the guise that there was a real advantage here for the removal. Well, I'll submit on my papers, and if there's no further questions.
Thank you.
And I thank
Very
you all for
helpful.
your time.
Good morning, Your Honors. May it please the Court. My name is Marissa Higgins, and I am here today on behalf of the appellee father in this matter. I am here today asking that this Court affirm the judgment of modification entered on September 6th, 2024 by the Worcester Probate and Family Court. First, the lower court did not err when it produced a complete, a thorough, and a thoughtful decision with respect to the issues raised in mother's complaint for modification, specifically her request to remove the minor child to Alaska. The trial court here issued a 22-page decision, including 150 detailed findings of fact, a rationale, and additional findings. The fundamental issue here is that mother disagrees with the court's decision, and rather than accept that court's decision, she is here seeking to first change the law with respect to removal. She's asking this court to do what it doesn't have the power to do. This court doesn't have the power to alter, to overrule, or to decline to follow the holdings of the Supreme Judicial Court. So the request that we cast aside the real advantage, which mother was able to establish in this case, in favor of a purely best interest standard, can't be done. But then when we look to the weighing of the evidence, this court crafted detailed findings. The trial court found the benefits to mother. But as the Giannis court warns, simply because there is a benefit to the custodial parent to remove a child from the Commonwealth does not mean that it's in the child's best interests. And the judge did a very detailed analysis of why removal would not be in the child's best interests here. Both the GAL and the court found that there would be no reasonable substitute visitation because of mother's conduct in this case. She would not allow for it. That the result of allowing the child to be removed to Alaska would be an elimination of father's relationship with the child. And I think the trial court sums it up when the court wrote, if the child were removed to Alaska, mother could add 24 hours of travel and the difficulty of out-of-state litigation she continues to place between the father and his parenting time. If father were unable to surmount these obstacles, whether for financial or other reasons, his relationship with the child would be effectively eliminated. And there was ample evidence for the court to make that conclusion. I will say that mother's request to remove the child to Alaska is based solely on her remarriage to a gentleman who was in the military. The court found that mother's new husband has enough years of service that he could retire with a full retirement package. And the Preveno case says that the court can consider the opportunity for jobs closer to Massachusetts when it looks at removal. Here, the new husband testified that he had no intentions of seeking to retire from the military. The court noted that mother married her new husband with full knowledge that he would be moved from place to place, and that she also recognized that she may not be permitted, or the child, I should say, would not be permitted to move place to follow mother's new husband.
What do you say in response to Mom's counsel's argument that there's no case that's held that the removal would be in the custodial parent's real interest, but that it's not in the best interest of the child?
Oh.
A real advantage is what I meant to say.
Certainly, Your Honor. First of all, I did cite a case in my brief, and that case is Murray v. Super. In Murray v. Super, mother remarried a gentleman who lived in California. The court found a real advantage to the move. The Pisano case sets forth that marriage is a per se real advantage. The mother, her family all lived in California as well. Mother sought to remove the party's 3 children to California, and the court denied the request for removal, and that case was upheld on appeal.
Thank you.
Certainly. If you have no further questions for me, I'm pleased to rest on my brief.
I think implicit in the judge's findings, well, I think explicit in her factual findings, but implicit in her conclusions are the relationship between the child and the father. Can you describe how that factors into the best interests of the child?
Certainly, it's a careful weighing of the child's interests, the mother's interests, and the father's interests. And the child and the father had a warm and loving bond, despite what the mother attempted to portray as the relationship between child and father. Dr. Ramachi, the expert who testified at trial, observed father and the child for approximately 6 hours, and he stated that they had a warm and loving bond. He stated that it is important that they have frequent and consistent parenting time in order for that bond to continue to grow. That's important in this case because there is so much evidence of the attempts that mother has made to frustrate rather than foster the relationship between a loving father and their child. It was truly, truly horrifying, some of the evidence that came out at the time of trial. Mother telling the child, your father wanted you aborted. Mother telling the GAL in the presence of the child that if father loved you, he'd allow you to be removed to Alaska. And in this case, I think it is very important to weigh the father's interests along with the child's interests here because the relationship would be eliminated if removal were allowed.
Thank you.
Thank you.
So we'll call the next case. It's number 2024 P1355, Department of Children and Families versus Father. And I understand we have very experienced counsel here, but I would remind you that this case is impounded, so please do not refer to any of the parties by name. It's fine to say girl, boy, father, mother.
No clock back there. I know. You saw the trial courtroom.
It's 11:50.
I think it's still barely morning, so I'll say good morning, Your Honor.
It is morning. Thank you.
May it please the Court. Steve Rosenthal, representing the father appellant. The main reason that the trial judge found that father was unfit in this matter were 2 basic pillars. One is that he was involved in substance use, also that he had a violent nature, which manifested, according to the judge, in various ways, criminal activity and domestic violence. I want to take a look at the evidence that was actually presented to put some of those determinations in perspective. First of all, the DCF became involved with this family at the time of the first child's birth when mother was found to be substance exposed. And in the 2 or 3 days following the child's birth, there were instances where father was angry, he was rude, he yelled at hospital staff members. At one point he became so agitated that security had to escort him out of the hospital and tell him not to come back. That's all admitted, okay? A few days later, on August 7 and 10, there was a 2-day temporary custody hearing, and with all that information before him or her, the judge granted father conditional custody. And I would suggest that no trial judge would grant conditional custody to a parent who is accused of packaging cocaine or making threats or acting in a violent way.
You said accused of. So
Mother,
I'm confused by your argument, because on the one hand, it sounds as though you're saying the judge couldn't rely on allegations of criminal conduct if they're not proven. But now it sounds like you're saying if the judge gave the dad conditional custody and knew about unproven accusations, the judge must have disbelieved the unproven accusations.
well, the judge determined that the evidence before her did not meet the standard, which was a fair preponderance of the evidence. And this is the same information that the trial judge used later to build the case that, oh, father is always violent and he's always threatening people. So my position is that because the court was aware of those incidents and nevertheless granted father conditional custody, which he had for something like 16 months after this child's birth, it kind of lessens the weight of that evidence of what occurred immediately after the first child's birth. The second incident of alleged violent behavior and threats made to the mother occurred after the children were removed in December of 2021. And the date was December 7. There were allegations by mother that father had threatened her. What's interesting is that one of the mandated reporters on that date encountered father and found him to be sober and calm. I don't know if calm is the right word, but he was not in an agitated state. And those are the two incidents where there's actual evidence where the father did something that contributed to a finding that he was of a violent nature. Now, I would say that from the time of the children's removal, because he was granted temporary or conditional custody of the second child as well, despite all of the information that had come in before. From December of 2021, when both children were removed, father had weekly 1-hour visitation. From May of 2022 until the end of trial, February 2024, he had 2-hour weekly visitation. And I did the math, you can check me on that, but he spent over 200 hours visiting with his children. And he had critical eyes on him. These were supervised visits. If at any point he acted out of line, became agitated, made threats, complained about the case, anything of that nature, you know that DCF would have reported it. And in fact, they submitted, I believe it was something on the order of 16 reports to the court during the course of this litigation. And not a single one mentions anything about father's visitation with these children. I would also point out that there were other witnesses who testified that throughout these periods, father was consistent with meeting with DCF every month. He was consistent in bringing at least the older child to daycare. The older child always appeared to be fed, cared for, well-dressed. So where is the evidence that this guy is violent, basically out of whack? And I would suggest that the evidence was few and far between. Now, He had a criminal history. The judge pointed out, well, that criminal history runs from 2006 to 2023. Well, let's put that in perspective. First of all, in 2006, he was a juvenile. So I'm not sure that those incidents that he was involved in back then when he was a juvenile are even to be considered. But he only had one conviction and two continuances without a finding arising out of the same incident that occurred in 2012.
What do we do with the fact that his action plan, dating back to at least January 2021, said refrain from illegal activity and notify DCF of any concerns, but he didn't notify DCF about several of the incidents?
Your Honor, that's what the judge found. Those are the facts. I can't dispute those. I would say that some of the incidents that he was accused of were either, well, there were two incidents. One was the alleged baseball bat incident, which occurred in June of 2021, and father got conditional custody of his child, of the second child, on November 1st of 2021. The other was the alleged knife and potential stabbing incident from July 1st of 2023. And that case was dismissed. Now,
Right, but it seems, unless I misread it, it's not that the judge was relying on the criminal history per se, but more, I think, as Justice Grant alluded to the father's lack of candor about that or communication with the department, no?
well, I would suggest that parents are, their rights are terminated based on the things that they do, rather than the things that they are accused of doing or the normal failings of the average parent.
Okay.
So I would suggest that the knife incident, by the way, the police reports, I went through those in my brief. The police reports indicate that there were 3 witnesses to this incident, none of whom confirmed that there was a knife present. They said it was a verbal altercation, and there was no knife found on father. He wasn't, it simply wasn't a rational basis for finding that father actually did something that would confirm his violent nature. Now, with respect to his substance use, when DCF first became involved, he reported, and DCF accepted, his statement that he had been sober for 16 months up to August of 2020. He had 2 relapses after that. He had a relapse in late November, early December of 2021, and he had a relapse of maybe a couple of days in May of 2022. So if you go from February of 2019, when he says he began sobriety, through the end of trial, February of 2024, you have 5 years, and in those 5 years, there were 2 relapses, okay? And as I said before, after 200 hours of supervised visitation, monthly visits with social workers, daily contact with daycare providers, nobody ever suggested that father showed signs of intoxication. He wasn't falling asleep.
Assuming relapses are a fact of life in cases like this, couldn't the judge find that it wasn't the relapses per se that were problematic? It was the fact that the father didn't rely on his supports as he said he was going to. The father couldn't articulate a relapse prevention plan. The father lied to DCF on many occasions about whether or not he was taking Vivitrol. What do we do with that, as with the criminal issues, it's not the It's not the crime, it's the cover-up.
Seems to me we've heard that accusation before in other contexts. Well, in response to that, I would say that while father could not articulate his recovery plan, his safe plan at trial, there was testimony or there was documentary evidence, and I refer you to Trial Exhibit Volume 1, page 180, when in February of 2023, the DCF interviewed father's therapist at the time, and he went through a couple of different therapists because people would leave, he'd be on a waiting list, and he'd get one. And the therapist who was interviewed in February of 2023 said that father had been in weekly therapy at High Point since October of 22. He had made tremendous progress and effort and can easily express the protective factors that allow him to prevent relapse. Now, maybe he couldn't articulate that in court, which I think any of us would agree can be a stressful circumstance, but in therapy, he was able to do that, and his therapist was convinced that father has had relapses, but he can be successful. And that's my point, Your Honor. Yes, father was evasive. Father didn't report things as soon as they happened. But father showed an extensive period of sobriety marked by 2 incidents of relapse. And I would say that that shows that he has a reasonable likelihood of success in the long term of maintaining sobriety. One other point.
Before you run out of time, could you talk about the simultaneous visitation issue?
It's not my strongest argument, Your Honor, but it just seems odd to me, excuse me, that the judge, after knowing that the parents had had separate visitation for several years while this matter was pending, orders simultaneous visitation afterwards. And I would also point out that the judge, despite all of father's shortcomings that she found in her findings, she gave him monthly post-termination visitation. And I've been doing this for a while. I would presume you've heard many of these cases. How many cases have you heard where a parent's rights were terminated, but he or she was given monthly visitation with the child? That seems, I'm not saying it's excessive, I'm saying the matter should be remanded, but I am saying that it gives some indication of what the judge actually thought father was in what way father was falling short and unfit. If there are no further questions, Your Honor, I will rest on my briefs.
Thank you.
Thank you.
Now, I understand that you're splitting time, 10 minutes and 5 minutes?
Yes, Your Honor. May it please the Court, Jeremy Bayless for the Department of Children and Families. The role of a judge in review and redetermination proceedings is to assess whether or not, or sort of what trajectory the parent is on. Are things staying roughly the same? Are they improving or are they getting worse? In this case, at absolute best for father, they were staying the same. Father had had years of struggling with substance abuse. That struggle was marked by progress while he was taking Vivitrol and properly engaging in substance abuse services and whatnot. And then father would, of his own accord and while telling no one, stop taking Vivitrol. And then he would almost immediately relapse severely. And then he would get back on it and he would do well. And then he would choose to end his treatment and relapse again. While relapse is a part of the recovery process, nonetheless, judges have to look at the children and whether or not it looks like things are improving such that the child may potentially be safe. And at the time of trial, father was not taking Vivitrol again. He had taken it for roughly 3 months in 2022, stopped, relapsed, started again in late 2022, took it for a month or two, and then stopped on his own accord at the time
Attorney
of
Bayless,
trial.
would you concede that this case on this record is at least closer call than many that we see?
Oh, it's certainly closer, but those are those are the hardest ones for the trial court to make. And that's why it is important that there is a deference to the finder of fact, who is actually seeing father testify. In his reply brief, father argues that basically everything involving mother should be reviewed de novo because mother didn't testify. But what is a problem with that argument, and a general problem, is that the father testified at trial. Father testified about his understanding of substance abuse. Father testified about his lengthy history of criminality. And part of assessing those close calls is evaluating the witness. And what the judge found was that this is a father who does not appear to understand what he needs to do to address any of his parental deficiencies. Visits went well. He had a bond with the children, which is why there was a visitation order. But the problem is, if the children were returned to his care, they would be at the mercy of his cycle of relapse. And they're not mild relapses. Their father is found, almost catatonic. He has to be revived. He is briefly agitated with the police and is then hospitalized. It's father is using, so mother comes back in the home, and then father and one of the children finds mother unconscious in the bathtub, and then father then tells at least 3 or 4 different stories about what actually happened, so that no one can address what the children were or were not exposed to because they don't know until it's later sorted out. Father says that he has no criminal record. He says this to the court investigator. He says it to service providers. And then father is arrested multiple times for violent assaults during these cases. And the police reports have identified declarants saying, I saw father with a knife. Let me describe the knife to you. The knife is described by an identified declarant in the police report. Record Exhibit 2, 329 is where it starts. Same with the baseball bat assault. The police report, while a lot of the information is second-level hearsay from the victim's mother because the victim was unresponsive in the hospital, police report also says the victim woke up, and to the extent he was able to communicate that father assaulted him with a baseball bat. And while those did not result in convictions, one of them was not dismissed until after the review and redetermination proceedings were over, which would then obviously make that outcome not air for the judge to not know that it happened. Case law in Massachusetts allows those facts to be considered the same as any other testimonial evidence. And that's the case because the focus of child welfare proceedings is the best interest of the child. Civil standards of proof are different from criminal standards of proof. There's a variety of issues that are well established in the case law. So we know that this is a father who struggled with substance abuse. And he did make progress until he chose to terminate that progress, and he did that multiple times. It led to the children being removed from his conditional custody. This is a father who struggled with violence and impulsivity, and that continued through the trial. It continued to be a viable parental deficiency at the time of trial, and it led the court to conclude that it was not likely to improve because father was not taking steps to improve it. Instead, he was concealing it, and he was not engaging in good faith with providers. When he did engage in services, he did not complete them. He started a violence program and then was asked to leave for non-payment. And due to his behavior, well, non-payment is obviously not that big of an issue, but also due to his behavior during the meetings. And so we have a parent who is frustratingly capable of addressing at least some of his deficiencies, but was not doing so. He had already stipulated to his unfitness, had an extended period of time to take those steps, and did not. And the fact that the juvenile court did find that this was an unfortunate situation in which there was a close relationship between the father and the children, that the children would be harmed by the abrupt severance of that, such that a visitation order, an above-average frequency visitation order, was necessary, doesn't change the fact that a parent can be safe to visit with children, but not safe to have the children live with them.
Is there a cost, counsel, to, let's say the judge determined the father was temporarily unfit, but not permanently,
Yes.
and allowed these monthly visits. Is there a cost to the child to revisiting whether or not father is fit or not?
I'm sorry, do you mean like a permanent custody order with this visitation schedule as opposed to a
I think
termination?
what I mean, could the judge balance whether, again, terminating the rights and allowing visitation versus not terminating the rights, but allowing the visitation and revisiting the father's condition? Is there a cost to the child in that world?
There is. As is pretty well established, childhood is fleeting. Children only have so much time as children, and that is a massive developmental period. It shapes who they are for the rest of their life. And a lack of permanency and stability that comes with the uncertainty from that is something that is to the children's detriment.
The termination order gives certainty.
Yeah, that's adoption of Nancy and in numerous other cases. And what it also does is it makes it easier. Obviously, no portion of this is the department's convenience. It makes it easier for the children to find an adoptive, a permanent resource. There are more people who are open to the idea of adopting a child who is freed for adoption rather than starting that process and potentially having it fall apart because the parent becomes fit. So there's more options to facilitate that permanence when termination is done. And to get to your question, Justice Grant, about the simultaneous visitation, I think that's what impacted that decision there, which is in any order for post-adoption visitation is some level of burden on the adoptive parents who have the full rights as parents of their children to control visitation and access to the children. And so while it is an unexpected choice to go from separate visitation to simultaneous visitation, it is certainly not an abuse of discretion for the court to feel one visit is better than two visits, especially 4 annual visits. That's 4 to 8 for any pre-adoptive parents, and the expectation that the parents can behave themselves for 1 hour of visitation, and if they cannot, the children or the adoptive parents can then seek an amendment of that visitation order. That's not an abuse of discretion. That's an acknowledgement of the reality of having children who will be living with adoptive parents and who will be subject to some level of disruption around those visits.
I just have a question about the record.
Yes.
There's the great aunt who is referred to in some places as the father's aunt and in some places by name, and she's one of the potential adoptive resources. Are those all the same person? Is there more than, I know that the girl is with her maternal aunt, not great aunt.
Yes.
So that's a different person as I understand it, but the great aunt is all the same person?
I believe it is. I believe at the time of trial, they were in separate placements, but the department was pursuing one great aunt as a potential option.
Who was the same person that, in the bathtub incident, the dad originally said the kids were with her and?
I believe so, yes.
Okay.
I am not sure that is, I did not go outside the record in prepping for the current status, but I am not sure that is still, but that's where it was at trial.
Okay. Thank you.
I see my time is up. I will rest on my brief, and thank you so much.
Good morning, Your Honors. Tamika O'Brien, afternoon. Tamika O'Brien on behalf of the children. Your Honors, in prepping for this argument today, I did go outside of the record to determine the children's status. So if you are interested, let me know. Otherwise, I will not bring that up. I wanted to direct you to finding of fact 118 and 119. And I was reading this morning, and what this kind of stuck with me is father testified about the impact of his substance abuse on his children was not good. But when he was questioned a little bit more on this, he testified, "I wish my brother and mother had more time to be with the kids." And the court found that his testimony did not address the impact of his substance use and or mother's on his children. And I think that that really says something here, that father did well at the visits, so well that the trial judge determined that there was a bond there and that that bond should be upheld. However, it says a lot that the trial judge recognized that while a father might have had a good bond with the children and was able to manage those visits, and it's really commendable that he did those visits because it doesn't always happen in these cases, but as far as fitness as a parent, the day-to-day stuff he was not going to be able to do. He couldn't really do it for himself consistently. He would do some classes in domestic violence, sometimes he did therapy, sometimes he was on the Vivitrol, but it was never consistent. And with children, you have to be consistent. And I think in this case, the trial judge recognized that, yes, maybe the facts in this case weren't as terrible as sometimes we see, but the bottom line is childhood is fleeting, and whether or not the father was fit to actually parent these children versus fit to visit them were two different and separate things. And in this situation, the trial court in 183 findings of facts and 34 conclusions of law detailed father's character, temperament, conduct, and capacity, and determined that his grievous shortcomings placed the children at risk of future harm. And that's what we're looking at here, future harm, because in 4 years between the birth of his daughter and the termination of his parental rights, he wasn't able to show to the court or DCF that he could be consistent with his own journey for substance and mental health, and to refrain from criminal activity, whether or not those were convictions. And children need that kind of stability in their lives. And so for that reason, Your Honors, the children are requesting that the trial court's determination of father's termination of father's parental rights remains. I don't want to stand up here and repeat anything else, but if there are no other questions.
Thank you both
Thank
very
you.
much.
Have a great day.
Very helpful. I would like to take this opportunity to thank Officer Guarino and Officer Alpert and our timekeeper and our law clerks, and the court will stand in recess. Thank you.